Assalamu alaikum friends. How are you all? So this is corporate and business law. We are going to do corporate and business law paper, and this is also a multiple choice questions, okay? And we are going to do the English version, okay? Corporate and business law, the English one. So let us start. And before I start, let me remind you once again that I have previously done the first three papers: business and technology, that is F1, management accounting F2, and financial accounting F3. So if you haven't checked those videos, go on and check those out, okay? So let's start. Okay, this is a 2-hour paper. As all ACC papers, 50% pass rate, and section A we have 45 questions, 70%, and section B 5 questions, 30% from here. Okay, the nature of section A and section B, the question looks different. In section A, it's simple, you just have to select out of the 4 or 3, but section B, a case study will be given to you. On that case study there will be questions which you have to select. Okay, so let's start the exam. Okay, so which of the following may imply terms into contracts? Okay, this tells you that this will also be helpful for those students who wants to know what is inside this without even purchasing the textbook and the revision kit or anything, or attending a class, by just looking at the questions. Okay, so which of the following may imply terms into contracts? The parties to the contract, the third parties, or the statute? Okay, it is the statute. What is statute? You will know when you study law, when you study the corporate and business law. Under this, everything is defined. Okay, there are a number of ways in which investors can take an interest in a company, and such different interests have different rights attached to them. Which of the following normally participate in surplus capital? Debenture secured by floating charge, ordinary shares, preference share, or debenture secured by fixed charge? It is ordinary shares. Okay, next. In the context of English legal system, which of the following courts only has civil jurisdiction? Magistrate court, county court, high court. Okay, the functions of each court are there in the law. Okay, and let me tell you that law is something where you have to memorize a lot. It's like more like memorization. Okay, you have to memorize lots of details and all. So this also could be a paper where a student can get 100 marks. 100% can be scored. Okay, not at all tough. The only thing is remembering the facts and all, which makes it a little a bit what do I say, complicated, but other than that it's easy. Okay, so in the context of English legal system, okay, it is the county court. Okay, what is county court, what is magistrate, high court? It's defined in your corporate and business law. Next, so basically what we are studying is we are studying UK law. Okay, that's what we are studying, and it's relating to business law, not any law, because law, if you say, it is divided into many parts. There are so many divisions in law. We are focused on business and corporate law. Okay, so in the context of employment law, like employment laws and how the contracts are set when a business, in partnership or limited companies, all those stuff. So in the context of employment law, which of the following is automatically fair ground for dismissing an employee? Legal prohibition, unofficial industrial action, redundancy, refusal to join a trade union. Okay, it is unofficial industrial action. Which of the following business forms does the use of abbreviation LTD after the name of business indicated? Limited liability, limited partnership, or private limited company? It is private limited company. Okay. JS has been continuously employed for 6 years. Which of the following states the minimum period of notice is entitled to? 1 month, 6 weeks, or 3 months? You see, you have to remember these facts. That's it. You just have to remember the facts in law. That's it. So it is 6 weeks. Next. Which of the following is indicated by abbreviation LTD at the end of the company's name? The shares are not transferable. The shares may not be offered to public. The shares are freely transferable to the stock exchange. Okay. The shares may not be offered to the public because it is in the private limited company, right? If you offer to the public, that means it's a public limited company. In public limited company, you don't use LTD. Okay. Next. So a lot of sections you have to remember. Okay. A lot of ads sections you have to remember. Because this question, section 122 insolvency at 1986 specifically provides a distinct ground for applying to have a company own up to the ground that it is just unequitable to do so. Okay, Which of the following parties may petition to have a company compulsorily wound up under the provision? Creditors of company, secretary of state, shareholders of company, debenture holders of the company. Okay, so it is the shareholders of the company. Okay, to know all this, you have to know this Insolvency Act 1986. Okay, next. Mo has a significant holding in the shares of a Nova Limited. He wishes to use his shareholding to remove woman from the board of directors, but it is not sure how to do so. Which of the following must be used to remove a director from the office? An ordinary resolution with special notice, ordinary resolution, written resolution, special resolution. Okay, it is an ordinary resolution with special notice. You just cannot throw a director out of the office. For that, you need an ordinary resolution but with a special notice. Okay, and a written ordinary resolution requires the approval of which of the following? Unanimous approval of those entitled to vote, more than 50% of those entitled to vote, or more than 50% of those actually voting. So it is more than 50% of those actually voting. Okay. Employment law is a mixture of common law and statutory provision. Which of the following is purely based on statute law? Summary dismissal, unfair dismissal, wrongful dismissal. It is unfair dismissal. It just have the statute law, no common law. Okay, for unfair dismissal. So if you see, it's more like employment contract, or what does the contract includes, all those things. Okay, so Jo's contract of employment states that she's employed in Glasgow. When her employer tells her that she has to be working in London, says 500 miles away, Jo immediately resigns. Which of the following may this be considered an example of? Summary dismissal, constructive dismissal, or unfair dismissal? It is constructive dismissal. Okay, what is this summary dismissal, constructive, unfair dismissal? All there in law. Okay, corporate and business law. So there in your textbook. You can even Google and check for those who are planning to think. Okay, because some of you might take this paper as the first paper, so you don't have any idea what it includes and all. So you can just Google and check. Which parties are bound by the terms of tender when one party submits a tender? Neither party, person submitting tender, both parties, person requesting the tender. Okay, it is the person submitting the tender. Next, in the context of contract law, so you will have to know what is a contract law. Okay, a bid and auction is which of the following? Invitation to trade, offer, counter offer, or an acceptance. It is an offer. Okay. B injured her eye after failing to close a safety gate on a machine as instructed. She was also not wearing mandatory safety goggles as required by her contract of employment. Contract of employment you have to know, because most of the questions if you see are on contract of employment only. Which of the following is this an example of? Contributory negligence. Okay, this terms you have to know. Okay, you have to know what is contributory negligence. You have to know what is res ipsa locutor, or volenti non fit injuria, or novus actus intervenens. Okay, however you pronounce it, but these terms you have to know. Okay, you can Google and check. Okay, so don't get shocked by seeing these words, very, what do I say, difficult words and all. It's not at all difficult. Okay, because this is law. So in law you have to you can expect such words. Okay, so it is this volenti non fit injuria. What is the effect of finding of a contributory negligence in the law of tort? Okay, law of tort also you have to understand what is law of tort. It removes the requirement to pay damages, it decreases the level of damages, or it reverses the payment of damages. What does it do? It decreases the level of damages. Okay. Next. In the context of English legal system, which of the following code only has a criminal jurisdiction? County code, magistrate code, or crown court? It is the crown court. Okay. They deal with criminal only. There are two what do I say, division to law. One is civil law, one is criminal law. Okay, we are focused on the civil law relation to business contracts and all those things, employee contracts, safety of health of employees and all those things. Okay, so Imran claims that Zach owes him £1,000 as a result of breach of contract. In which court will Imran start his action against Zach? Magistrate, county, high court. Okay, what it will be? It will be county court. Definitely not high court. Just now we saw it is for the, sorry, definitely, oh, the crown court is not there. Okay. If it was crown court, then definitely that's not an answer, because crown court we saw it was for the criminal. Okay. In the context of the case, which of the following applies to an obiter dictum? It is not binding outside the court if it was issued in. It is binding on all future courts. It was not binding on all courts. It is binding on all lower courts. You have to know the term. Okay. So it is not binding on any courts. Next. Contributing negligence arises as a result of the following, which of the following: the claimant, the respondent, the third party. What is the claimant? What is the respondent? Okay. And what is the third party? All these things, just Google and you will get it. Okay. Now the world is very easy. Everything is on the tips of your finger. Just Google and get it. Okay. You don't need someone to explain what it means. Okay. You yourself can find out what it means. So, what is it? It is the claimant. Okay. Next. Anne got trapped in a public toilet due to the lock being faulted. Rather than wait for help, she tried to climb out of the window but failed and broke her leg. What is the example of this? Contributing negligence, or the second, or the third, or the fourth? It is the contributing negligence. Okay. Next. The law treats employees differently from the self-employed and has established a number of tests to distinguish between the two categories. Which of the following is not a test for establishing employment relationship? Okay, this test also you have to know. There's a test to establish whether you are self-employed or not self-employed. So which of this is not the test? The subordinate test, the control test, the integration test, the economic reality test. Okay, it is the subordinate test. Next. Breach of which of the following term does not allow the possibility of the aggrieved breach of which of the following term does not allow the possibility of the aggrieved party terminating the contract? A condition, a warranty, and innominate term. It is a warranty. Okay, if you have breached a warranty, you cannot terminate the contract based on that. Next. Which of the following, in the context of entering into a contract, constitutes a binding offer to sell a unique item of furniture? Placing it on display inside a shop with a price attached, telling someone the price you may be willing to accept for it, telling someone you will reduce the market price on it by 10%, or placing it an advert in a newspaper with a price attached. Okay, telling someone you will reduce the marked price on it by 10%. Okay. Next. Mark has received the agenda for the annual general meeting of ROVA, a company he has shares in. The agenda contains a number of resolutions to be proposed at the meeting, but being a new member, Mark is not certain as to what is exactly involved. In the context of company meetings, which of the following must be passed by a 75% majority to be effective? Ordinary resolution with special notice, written resolution, or a special resolution? It is a special. This. Okay, to get that special resolution, 75% majority. You have to pass that test. Next. Again, Section 122 Insolvency Act 1986 provides a number of distinct rules for applying to have a company wound up on a compulsory basis. Which of the following is not a ground for the compulsory winding up of a company under that provision? Company has suspended its business for 12 months, company has altered its primary business within first 12 months, or company has not received a training certificate within its first 12 months, or the company has not started trading within the first 12 months. Okay, it is the company has altered its primary business within the first 12 months. When you have altered the primary business within first 12 months, you cannot compulsorily wound up. Okay, according to this provision. But for the other three, you can. If you have suspended the business within 12 months, you can wound up. Or you have not started trading within first 12 months, you can wound up. Or if you have not received a trading certificate, you can wound up. But not when you have changed the business, the primary business. Next. A, B issued an invitation to tender for a contract and B submitted her terms. Which of the following statement is accurate? Okay. So options are there in front of you. Which of this? It is Ab has made an invitation to treat and B made an offer. Okay. You have to know who is making the invitation to treat and who is making the offer. These things you have to know. In the context of statutory interpretation, which of the following requires judges to consider the wrong which the legislature was intended to prevent? The golden rule, the literal rule, the mischief rule. There are three rules. You have to know all the three rules. Okay. So what is this? This is the mischief rule. Okay. It is not unusual for some company investments to carry cumulative dividend rights. Which of the following statements about the declaration of cumulative dividend is correct? Okay. So it is they are paid when profits are available for that purpose. Next. Which of the following statement is in relation to effective consideration is correct? It must be adequate but not need for sufficient. It must both be adequate and sufficient. It must be sufficient but not need to be adequate. Okay, they are talking about effective consideration. It must be sufficient but need not be adequate. In the context of English legal system, which of the following defines the ratio descendenti of a judgment? Facts of the case, decision in the previous case, legal reason for deciding case, or future application of the case. It is the legal reasoning for deciding the case. Next. Dan has been accused of a criminal offense and is due to be tried soon. He denies responsibility, claiming that the prosecution has no evidence that he committed the offense in question. Which of the following describes the standard of proof in a criminal case? In a criminal case, okay? Because it's different when it's a civil case and when it's a criminal case. Beyond evidence doubt, on the balance of certainty, on the balance of probability, or beyond reasonable doubt. It is beyond reasonable doubt. Beyond reasonable doubt. It is criminal case. It cannot be on the balance of probability. Okay, there has to be no doubt for that, beyond a reasonable doubt. Okay, they are very strict when it comes to criminal case compared to civil case. Which of the following statements related to a limited liability partnership is correct? They are limited to maximum of 20 members. They have at least one unlimited partner, or they have a minimum of 2 members. Okay, they must have a minimum of 2 members. Okay, definitely a partnership cannot be start without 2. Okay, it needs more, at least minimum of 2 members are needed to have a limit partnership. Next. Ho subscribed for some partly paid up shares in Low Limited. The company has not been successful, and Ho has been told that when Low is liquidated, he will have to pay the amount remaining unpaid on his shares. However, he is not sure to whom such payment should be made. In limited liability companies, shareholders are liable to which party for an unpaid capital? Liquidator, company, directors, creditors. Okay, to whom? They must, the company. Okay, it is the company. Because in a limited liability company, the shareholder and the company, they are two separate legal entities. Okay. Which of the following cannot petition for the compulsory winding up of a company on the grounds of insolvency under 122 Insolvency Act 1986? Secretary of State, the company is credited, the members of the company or the board of directors. They cannot petition for the compulsory. Who it is? The members of the company. Money laundering, okay? So definitely money laundering and all will come. Okay, money laundering involves a number of phases in the overall procedure. Which two of the following are recognized phases? Recognized phases in money laundering: integration, layering, relocation, or distribution. It is layering and integration. Both has to be there. If you select one, okay, you will not get the 2 marks. It will be awarded as 0, not even 1 mark. Next, which two of the following are automatically unfair grounds for dismissing an employee? Engaging in trade union, constructive dismissal, dismissal on transfer of employment to new undertaking, or redundancy? Which two of the following? It is engaging in trade union activities. Unfair, right? You cannot dismiss someone because they are engaging in trade union. And the next one is dismissal on transfer of employment to a new undertaking. Next, in the context of the law of agency, okay, there's a law of agency also which you will be learning. An agent will not be liable for a contract in which of the following instances: when the agent act on their behalf, or when the agent intends to take a benefit of the contract and does not disclose it that they're acting as an agent, or when the agent fails to disclose that they're acting as such. Okay, you must have heard about the agent, the principal agent relationship and all, the agency problems, issues and all, right? So because to solve that, there's a law of agency also. Okay, so it is when the agents fail to disclose that they're acting as such. Next, the Employment Right Act. So this is also an act which you're going to study. 1996 sets out remedies in relation to unfair dismissal. Which of the following is not a potential remedy for unfair dismissal? Reinstatement, re-engagement, or re-employment? It is re-employment. Okay. Which two statements are correct in relation to design members in limited liability partnerships, LLP? Okay. They must not take part in day-to-day operation of the business. They have a limited liability. They are responsible for filing the LLP's account, or they are fully liable for the partnership debt. Okay, so one is they have a limited liability, which is correct, right? Next, they are responsible for filing the LLP's account. The term insider dealing relates to a number of potential criminal offences. Which two of the following are crimes in relation to insider dealing? Failing to report insider dealing, passing on inside information, concealing insider dealing, or encouraging someone to engage in insider dealing. Which looks like all are insider crimes relating to insider dealing, right? You need to select two. What is it? One is encouraging someone to engage in insider dealing. The other one is passing on inside information. Okay, these are crimes. To know this, which of these are crimes, because when you're seeing this, definitely all of them looks like crimes. It's hard to select two. You have to know, you have to read inside this insider dealing. There will be a section on that insider dealing. You have to know what are the crimes in that. So basically, this is just, as I told you before, memorizing laws, that's it. Okay, which of the following can be accepted as to form a binding contract? A supply of information, agreement to enter into future contract, quotation of price, or statement of intent. What is a binding contract? Okay, it is quotation of the price. The answer is. So make sure that you know what is binding contract. Contracts are legally enforceable agreements. Which of the following statements regarding contractual agreement is true? They must be writing, there must be evidence in writing, they need not be in writing. Okay, so they need not be in writing. Yes, you don't have to write something for the agreement or the contractual agreement, but it's better, it is advisable that you do it in writing so that there's an evidence. Later, if either party changes their mind or they don't go by the condition or the terms, in order to solve the dispute in the future, it's better to write down, but it not be. Okay, it's not a rule that it has to be in writing. There's no such rule. Next, in relation to the law of negligence. Okay, law of negligence is our law. Okay, that also you will be learning. A finding of voluntary non-fit injury arises from the action of which of the following? An unforeseeable event, third party, responding claimant. You have to know all these terms. Okay, responding claimant, in law these terms are only used. So it is what? It is claimant, the claimant. To answer this, you have to know what is this voluntary non-fit injury. Okay, and also the law of negligence. In the context of the law of contract, which two of the following statements in relation to a letter of the comfort are correct? So what is this letter of comfort? This also Google and check. Okay. It is a non-binding statement of present intention to pay a subsidiary company future debt. It is issued by a parent company. It is a binding promise to pay a subsidiary company's future debt, or it is issued by a parent company's bank. Okay, so it is non-binding statement of present intention, and the other one is it is issued by the parent company. Sorry, it is issued by the parent company. Next. So this with that we are over with section A, and section B question will look like this. You'll be given a small background and you'll be given different tasks. We have 3 tasks, okay? All are based on this background only. Okay. So let us go. As Limited operates a shipbuilding business which specializes in constructing and modifying ships in order to order. So in 2011, they entered into an agreement with Bob to completely rebuild the ship to Bob's specification for a total contract price. So they have given you the contract price 7 million. However, after completion, Job informed AS Limited that due to the downturn in the world economy, he no longer needed the ship. AS Limited has already expended 5 million on altering the ship and immediately started an action against Bob for the breach of contract. Are you understanding what's happening here? Bob has ordered the ship, and now he's like he doesn't want the ship because economy downturn and all. But as what he did, he has already expended 5 million for altering that ship, right? So it's like now they're taking action. AS Limited is taking action against Bob because he says he has breached a contract. Okay, so however, in the week before the case was to be decided in the court, AS Limited sold the ship for the same amount of money that they would have received from Bob. He have sold the ship to someone else, okay, by on the same amount, on that 7 million that he would have sold to Bob. So this is the case about. First, understand what the case is talking about. If you are not understanding the case properly, you will not be able to answer the task. Okay, if you're not understanding it in the first instance, read it again. Okay, so which two of the following statements explain the purpose of awarding the damages for the breach of contract? Okay, so go through the 4 options. So it is they compensate the injured party for any financial loss, and the next one is they put the party in the position that they would have had in the contract being performed. So these 2 things are there. Okay, and you can see that here you are getting the 2 marks, so you know it's correct. Okay, so you either can scroll down and go to task 2, or if you want just close this off, and so that task 2 goes up. Okay, because it's become very hard, right, to keep scrolling up and down. So close down the task once I over with it. Which two of the following statements in relation to the duty to mitigate loss are correct? Okay, so one is it lies with the party who suffers the breach, and the other one is it reduces damage. Third, what level of damages can I claim for the breach of contract? 0, 7, 2 or 5? It is 0. Okay, they cannot claim. Why? Because he has already sold the 7 million to someone else, so he cannot claim anything from Bob. That is 0. Next. Okay, again the same. A background is there. This is a different background, and then you'll have given the question. So Claire, Dan and Abe formed a partnership. So this is about a partnership. 10 years ago, although Claire was a sleeping partner and never had anything to do with running the business, last year Dan retired from the partnership. Abe has subsequently entered into 2 large contracts. The first one was with a long-standing customer, Craig, who had dealt with the partnership for some 5 years. Second contract was with a new customer, Hug. Both believe that Dan was still a partner in the business. Both contracts have gone badly wrong, leaving the partnership owing 50,000 to both Greg and Hug. Unfortunately, the business assets will only cover the first 50,000 of the debt. So which of the following states the liability of Claire as a sleeping partner? Okay, just make sure that you go through the option because I'm not reading the options for you. Okay, so she has full liability for partnership debts. Okay, to understand this, whether she has full partnership debts or not, you have to know Partnership Act. You have to go through it. Who will be responsible in that? What is a sleeping partner? Okay, you have to go through that to answer this. Here I'm just giving you the answers. I'm not going by the explanation why it is like this. For that you have to go through the law in detail. Next, task 2. Which of the following describes the liabilities of Dan as a retiring partner? Okay, so go through the options. So he remains liable to new customers who knew he was a member of the partnership unless he declared his withdrawal. Okay. Next is task 3. So from whom can Greg claim the outstanding debt? These things you have to know to understand this thing. Okay, because definitely this will not be in the textbook. Okay, who will Greg claim? This is something in the case study, but similar case study has been given to you in the case study when you were solving. That's why you have to go every case by case how decision has been given. Who is responsible to answer these questions? Okay, so who will be responsible for this? If, dead, and clear. Okay, you can claim for all these three. Next. So just see the time remaining here. You can see the time, right? And here you can see how much you have progressed. So 82% we have completed, and when you go down, this is for this question, question 48. And this is for your overall exam. So when it's 100%, you can exit. That means you are over. You have completed all the questions. So John, who is 65 years of age, who has just retired from his employment with a pension and lump sum payment of 100,000. He is keen to invest his money, but has absolutely no knowledge of business or investment. He does not wish to take any great risk with his investment, but he would like to have a steady flow of income from it. He has been advised that he can invest the following range of securities: preference share, ordinary share, debenture secured by floating, or debenture with floating charge. In relation to the above investment forms, which is the most secure? Okay, which is the most secure? This common sense, right? Your knowledge from previous studies also will help you. Law is not required here to answer this question. We all know which is the most safest. It is the debenture issued by fixed charge, right? Because it is fixed. We know that this is exactly we are going to get debenture. Okay. Even when a company is winding up and on liquidation purpose, when a company liquidates and all, who is the first one who gets it in according to the hierarchy? There's a hierarchy. Who gets the first payment? It is your creditors, long-term debtor, long-term creditors and all. So debenture holders will be the first one to get. Then comes the preference share, then comes the ordinary share. Ordinary share is the last one, so it is the most riskiest. They might not get also at times. Okay, if it's a floating charge, it's not so secure. Fixed charge, yes, definitely you will get this amount. You're sure you're more secure of that. So debenture is secured by a fixed charge. In relation to the above investment form, which may have a cumulative right to dividend. Okay, so even your financial accounting knowledge can help you with this. It is what? Preference share, definitely. Cumulative right to dividends is for preference share. And task 3. In related above investment which normally participates in surplus capital, it is ordinary shares. We have answered a question also, I think, in section A relating to that. Next. Okay. So in 2008, Ghar was disqualified from acting as a company director for a period of 10 years under the Companies Director Disqualification in 1986 for engaging in fraudulent trading. However, he decided to continue to pursue his fraudulent business, and in order to avoid the consequences of the disqualification order, he arranged for his accountant Kim to run the business on his instructions. Although Kim took no shares in the company and was never officially appointed as a director, he nonetheless assumed the title of the managing director. Identify which of the following categories of directors apply to each of this. De facto director, de jure director, non-executive director, shadow director. You have to know the terms of all this, what each of this means, okay? Otherwise, you will not be able to answer this question. Okay, so Gar is a shadow director and Kim is de facto director. Now, task 2. Which of the following categories apply to non-executive director? Just go through the options and okay. And mind you, when you're doing this, okay, when you're practicing this, definitely you'll be practicing this specimen paper at home. Don't look at your textbook or no nothing. Don't just look at any answer. Just do whatever you can. You might be wrong. Don't try to change your answer and get that 100%. Okay, you might be wrong, but you will learn from those mistakes. So make that mistake in the first place. If you don't make mistake, you will never learn from the mistakes. It's better to do 100 mistakes, okay, the same mistake 100 times while you're practicing rather than making the mistake on the day of the exam. Okay, they owe fiduciary duty to the company. Yes, that is the job of the non-executive director. Okay, if you look at the other things, these are the characteristics of executive directors. Non-executive director is like a monitor in the class. You're monitoring what others are doing, and then you are informing the teacher. It's like you're supervising. Okay, you're not involved in day-to-day business. No, you cannot have contract of employment with the company. No. Okay, they attend but do not vote at meetings. No. So they owe fiduciary duty. What is fiduciary duty? It is like a duty of trust. Okay, to the company. And finally, this is the last question for this paper. Okay, Fran and Graham registered a private limited company, IA Limited. January 2009, with each of them becoming director of the company. Although the company did manage to make a small profit in its first year of trading, it was never a great success, and its second year of trading it made a loss of 10,000. At that time, Friend said he thought the company should cease trading and be wound up. Graham, however, was insistent that the company would be profitable in the long term. So they agreed to carry on the business with Friend taking less on a part in the day-to-day management of the company, although retaining his position as a company director. In the course of next 3 years, Graham falsified Arc Limited's accounts to disguise the fact that the company had continued to suffer losses until it became obvious that he could no longer hide the company's debts and that it would have to go into insolvent liquidation with the debts of 100,000. So are you understanding what's happening in the picture? Graham is manipulating the accounts. He knows that the company is going in losses. He does not want to show the losses. He wants to conceal it. But after 3 years, what happened is, you know, it would have to go into the insolvent liquidation with the debts of 100,000. It cannot hide it anymore. So now, what type of action, civil, criminal, or both, can be taken in relation to each of the fraudulent trading and wrongful trading? Okay, first of all, you have to know whether it is civil or criminal, or it could be both also at times. Okay, if it's a wrongful trading, it is only civil only. Okay, but if it's a fraud, then it's both. Okay, to fraud is both civil and crime. Okay, it's a crime, it's a criminal offense, and also it's a civil offense. Next, does fraudulent or wrongful trading apply to each of the Friend and Graham? Okay, so you have to know, one is fraudulent trading, insolvency, and the other one is wrongful trading. So for Graham, okay, for Graham it will be wrongful trading. Sorry, Graham, I'm sorry, Graham is fraudulent trading, and Fran it is wrongful trading. Graham, okay, we saw Graham because when you see the task 1, Graham, he is involved in both fraudulent trading. So for fraudulent trading, it is both civil and criminal, and Graham is involved in that. Whereas Fran is only in the wrongful trading. He didn't do any fraud. Okay, it is Graham who wanted to conceal and falsify the accounts, and also he is both in the wrongful and the fraudulent. It's like a fraudulent trading. Okay, for doing frauds and all. So that's it. You can see that it is 100% complete, and this question is also 100% complete. So now I'm going to exit the exam. Okay, so here's the result. Okay, so definitely it should not be a case that you are not able to finish it in the 2 hours paper. Usually students finish it in 2 hours or even less than that. But if you're not able to finish it in 2 hours, maybe you're taking too much of time to think, that means definitely there is something is lacking in your preparation. You are not prepared enough. So you can check yourself along with the time also how much time you're taking. Okay, if it's less than within 2 hours, then it's fine. But if you're not able to finish it in 2 hours, then definitely something else. You're not prepared enough. So make sure that you prepare yourself with the time and learn all the things. Okay, everything from the syllabus has to be learned, all the laws, all the contracts. Okay, in a given situation you also have to see case by case. In this case, who was made the victim? Okay, who has suffered? So all those things you have to see case by case, and if a similar case comes to you in the exam, definitely the case might be different to what you have practiced, so you have to know. Okay, so that's it. And the next papers which I will be doing will be from F5, that is from performance management till audit. Okay, because financial management FM I have done questions already. You can go and check. And before this I have done F1, F2, F3, and this is F4, corporate and business law. Okay, because from the next paper on was F5 to F9. We have MCQs in section A and B, but we have a section C also there. Section C is included there. Okay, in that section C we have to do workings, we have to write, we have to type, or we have to do calculations in Excel. Okay, so that's why the nature of those 5 papers is a bit different compared to the first 4 papers. Okay, so the next video will be on one of it, the performance management, that is F5. So don't forget to subscribe to my channel and share this with your other friends who is thinking what is corporate and business law all about, so they can have a brief idea about the things which will be coming in that. Thank you and take care.